Welcome back. The British Columbia Court of Appeal is hearing a case on the constitutionality of child protection services in the province having unrestricted access to parents' medical records. Provisions of the Provincial Act allow for the Director of Child Protection and their social workers to collect private information of parents. That includes medical records. Information can be collected without parents' consent or notification and can be used to make unilateral decisions like removing children from their families. British Columbia's Civil Liberties Association has been granted intervener status in the case. It's set to argue that the Act's provisions are in violation of Section 8 of the Charter of Rights and Freedoms. Megan Giltro is a lawyer for the British Columbia Civil Liberties Association, and she joins us now. Thank you so much for joining us, Megan. Can you give us some background on the case that the BCCLA is intervening in today?
Sure, and thanks for having me. This is a case that arose from the discovery, actually quite by accident, by a mother, that her healthcare records had been accessed by the Provincial Ministry of Child and Family Development, the director, without her knowledge. And it drew attention to a provision that's in the child welfare legislation in British Columbia that appears to stand quite apart from other provisions in the legislation that provide sort of protective measures and checks and balances, and that give quite open scope for the director to access really any information that the social workers deem relevant that are being held by public institutions. And in this case, that was the regional hospital, a public institution. And it draws this provision in the legislation draws a real distinction between medical records that we all have an expectation of privacy over, that are held by, for example, our doctors in their private clinics, as distinct from medical records that may be held by, for example, a hospital, and provides much more open access to the government to those records.
Okay.
And
why did the BCCLA feel it was important to intervene on this particular case?
Well, there's a real concern over protecting rights of privacy, and especially privacy over health records, including, for example, therapeutic records, mental health records. But BCCLA was particularly concerned about the context in which this state access to personal information is happening, which is the child welfare context. And as we know, that's a context where there are great imbalances where the state's attention have been. We know that there's an overrepresentation of Indigenous children in the child welfare system, and that was a point that West Coast Leaf intervened to make clearly before the court. But BC Civil Liberties' concern is that far from being a context where the regular checks and balances should be relaxed, we should have heightened protections in these contexts, because we know this is a sphere in which the state's intruding into the lives of families, once been recognized as one of the most intimate spheres there is in our society. And we don't want to deprive the director of information that's necessary for the protection of children, but that doesn't mean letting all safeguards fly out the window.
Okay. Well, can you explain how the current legislation in the Child, Family, and Community Service Act is in breach of the Canadian Charter?
Well, it hasn't been determined yet to be in breach of the Charter, but the appellant's arguments in this case is that it does breach the Charter because it doesn't weigh the interests of protection of children with the, at the same time, interests of the protection of private personal health care information, and comes down to doesn't have sufficient safeguards in place to ensure that that really important balancing is happening. So, for example, there's no opportunity for a parent to even know that these records are being accessed, let alone to ask a court to have a look and oversee and make sure that only those records that are necessary for the protection of children, for the director to do their job, are being accessed, rather than too broad an encroachment upon personal information. So it's the safeguards. Balancing has to happen, but in the appellant's position in this case was well argued that there weren't sufficient safeguards, and so this was really just too wide open for the discretion of thousands of social workers.
Right. Now, the BCCLA claims there's a better alternative available to protect children and their families. Can you tell us about that?
Well, one thing we pointed the court to was how it's working in Ontario. Ontario has a model, for example, where when the Child Welfare Agency requires access to records in order to do their work, carry out their mandate, they have to go to court to ask for the records. They need to get an order. And that allows the court an opportunity to ensure that only the narrowest access to information is happening. And it provides a check and balance on the system. And there's good examples of the courts doing just that, doing what courts do, which is providing that safeguard. So we suggested that as showing a sort of frontline on the ground approach that is working, and in Ontario at least is not depriving the director of the records they need, is ensuring that the safety of children and families can be maintained, but is protecting the right to privacy.
Right. Okay. Well, thank you so much for joining us, Megan.
Thank you.